The next 7 slides are a really great summary of the laws and regulations that impact EEO law, and particularly the staffing side of things. The first column talks about the law or the executive order, and you should remember the difference between the two. They talk about who is covered or who is required to comply with this law in the second column. So, for example, Title VII, private employers with at least 15 employees, et cetera, are required to do Title VII. Then the general provisions. What is the basic rule that you need to follow? And what that basically means for Title VII is it prohibits discrimination on the basis of race, color, religion, sex, or national origin. And then the last column is just additional links and additional information that may be useful for you. And I think that's a really great list. So on this page, you've got Title VII, which, as you know, is the primary foundation for most EEO law. Remember, it was amended in 1991, so all those links on the right-hand side are connected to that to refresh yourself on those rules. Then you've got Executive Order 11246 and 11375 dealing with federal contractors and the requirement to do affirmative action. And again, the links on the right-hand side about what those mean and why they're important. Here on the second page, we have the Pregnancy Discrimination Act, which is a standalone act, but it really does extend upon Title VII in the Civil Rights Act. As it basically talks about how pregnancy discrimination is a form of sex discrimination because only women can get pregnant. The one at the bottom, of course, is the Americans with Disabilities Act. Again, passed in 1990. It's probably the most recent comprehensive EEO law passed, which was done in the early 90s. Again, private employers, 15 or more, have to comply with this, and it's qualified individuals, anybody who has a disability or is perceived to have a disability. So even if someone doesn't have an illness or a disability, but they are perceived to be disabled, they are still covered under the Americans with Disabilities Act. On the third page, we have two laws. One is an amendment to the Americans with Disabilities Act, and the other is the Genetic Information Non-Discrimination Act. And we probably didn't talk a lot about the GINA Act in Management 430. Certainly, we've talked about ADA. In 2008, the ADA was amended to adopt a broader standard of what is considered to be disabled. And so that's really the definition that we work off of these days, is making sure that we are encompassing that broader definition of who is or is not disabled. The Genetic Information Non-Discrimination Act, again, same thing, private employers of at least 15 or more. It prohibits discrimination on the basis of genetic information. So if we find out that somebody has the breast cancer gene, we can't fire them for that, or we can't tell them that we're going to not give them health insurance or things of all that nature. So there are a whole host of things where when we have that genetic information, we're not supposed to utilize that for making discriminatory employment decisions. If someone can do the job, that's really fundamentally the only thing that matters. So if we have to make a reasonable accommodation, we can do that. On this page, we have the Rehab Act of 1973, the Age Discrimination of Employment Act in 67, and the Immigration Reform and Control Act in 86. And we'll start with the Rehab Act. The Americans with Disabilities Act was largely modeled against the Rehab Act. But what the Rehab Act does is it orders federal contractors to engage in affirmative action to hire individuals with a handicap. And then what we realized, in the time between 73 and when the ADA was passed in 1990, that we just that wasn't enough. We haven't made enough inroads. And so the Americans with Disabilities Act really forced organizations to think more proactively about accommodating people who had a permanent or even temporary, to make sure that they get protected under the law. And then again, of course, as I said, the Rehab Act, if you have a federal contract, you have to engage in affirmative action. You have to actively recruit people who have a disability. ADEA, age discrimination, says it protects people 40 years of age or older. And again, there's links to that and in those interpretations. The issue with the ADEA is that it protects people who are older, but it does not protect people who are younger. For example, I can say to you, you're too young, I won't hire you. But I can't say you're too old, I won't hire you. So that's always a challenge. There are some ways of getting around it. A lot of organizations will make financial arguments, like this is a financial burden, what our salaries are, so we're going to lay off higher salaried workers for financial reasons. And some courts have allowed companies to be able to do that, but in the end, it still is subterfuge for getting rid of people who are older workers. And so we have to be really careful about the reasoning and the justification for it so we don't have any major problems around that. The last one, the Immigration Reform and Control Act, if you have at least 4 employees, which means pretty much anybody that's more than like a small handful of people, you have to do this. You have to make sure that people who are eligible for employment in your organization have the proper paperwork, and only citizens, U.S. nationals, legal aliens, and those with certain types of visas are eligible for employment in the United States. And so we have to verify that that is done. Now, E-Verify will help us with that, right? So most companies will engage in and have a subscription to E-Verify, but the bottom line is, even if we don't, we have to collect information on the employees. The I-9 form is what they're required to fill out, and they have to have the Social Security card, they have to have their passport, driver's license, but basically they have to verify that they are eligible to work here in the United States. Here on page 5 we have the WARN Act. And with the WARN Act, employers that have at least 100 employees who have worked 6 months or more in the last 12 months and who have worked more than 20 hours per week, they are obligated to give 60 days advance notice of a plant closing or a layoff of 50 or more employees. And oftentimes you can get around that by paying people through 60 days, even if you're going to let them go tomorrow. You'll pay them for the next 60 days. So in essence, it balances itself out. But it's really important if you're going to do a mass layoff, you do need to give people advance notice. It affects the individuals and their families, correct? Right? I mean, I think nobody would disagree with that. It's only fair and only right to give people some notice that they're going to be losing their job. But secondarily, this also has an impact on local communities. If you're doing a mass layoff in a local community, that community is going to have an impact. And so this way we can find ways to bring in, potential new employers, or to have career fairs for people, so that we don't have a community that suddenly becomes depressed because nobody's got a job, nobody's working, and nobody's making any money, so there's not a vibrant economy to support the local community. So a lot of these laws come into play because the goal really here is to make sure that people can participate in the labor market, that they can, and in our economy, that they can buy goods and services, and that they can participate and contribute to a thriving economy, and that's part of that goal. Here on page 6 we have the Uniform Services Employment and Reemployment Rights Act, the USERRA. And then we also have the Vietnam Era Veterans Readjustment Assistance Act of 1974. Again, both of these are dealing with uniformed people who've served in military uniformed services to protect them in some way. Under USERRA, all members of the uniformed services are covered under this, regardless. So it doesn't matter if you have 1 employee or 100,000 employees. Even with 1 employee, you are obligated under USERRA to protect and ensure that members are entitled to their civilian employment after they conduct their service. And this is particularly relevant for National Guard and Reserve people. In order to support our armed forces, the Navy, Marines, Army, Air Force, etc., without having a draft, we utilize our National Guard and our reserve often to meet the gaps where we need more personnel when we're in fighting zones and things like that. So USERRA helps by making sure that people are free to fulfill their obligation as a National Guard or Reserve member with the assurances that they can get their job back once they are returned from their tour of duty. In terms of the Vietnam Era Readjustment Act, again, this is subcontractors and contractors with the federal government have to do this. They want to prohibit discrimination and require affirmative action for disabled veterans. So similar to the Rehab Act, but this is focused specifically on Vietnam era's vets, and of course, in 2002, it was amended to the Jobs for Veterans Act. So it's sort of a broader scope now. It's not just Vietnam era, but it's a broader scope that we want to prohibit discrimination again and against the disabled vets. So it works hand in hand with the the Rehabilitation Act, but it specifically targets that, if we have a disabled vet, we want to proactively look for them and do our best to hire them and accommodate them in the workplace. The last law here on page 7 is the Consumer Credit Reporting Reform Act of 1996. In essence, any employer who does a credit check for the purpose of employment. For example, if someone is going to be bonded, if they're going to be working as a teller, if they're going to be handling cash in any way, you can do a credit check. And if the person does not pass their credit check, then you would be within your rights to refuse them employment, because someone who has bad credit is a greater risk for embezzlement of money from a company. Now, employers have to disclose in advance that the company is intending to obtain the credit report and get written permission. If you do not get written permission from the employee, you may not get their credit report. The person is then entitled to get a copy of their credit report, especially if there is an adverse hiring decision. For example, the person applies, they have bad credit, you refuse them employment. They definitely need to know, because certainly, as we all know, there could be errors on the credit report. And so if the person is rejected because of their bad credit, they have the right to receive their credit report and appeal if need to, if there are errors on the report. And so there's some of the statutes there on the right-hand side that supports that.